Good day, this is Sinta Ebersohn from Fair Divorce, and we're discussing a very, very interesting case today with Dean Tong, who's a forensic trial expert. Dean, thank you very much for joining me again.
Yes, thank you, Sinta, for having me.
We're going to talk about a very landmark case in Canada where sole custody was awarded to a father as the direct result of the behavior of the mother of the children. And I quote, her behavior was found to be controlling, intrusive, obstructive, and alienating. Dean, I'm putting it in lay terms, but from your expert experience, what does this mean for every parent out there who does not want their children to have a good relationship with their other parent? Can this serve as a stern warning?
Yeah, absolutely, Sinta. This is a quintessential case in parental alienation. The court went beyond what a normal court would do to rule the mother's behavior was alienating, to actually deem it family violence.
Yes.
And the words family violence have been injected now into the Divorce Act in Canada. So it's a case where I think all attorneys and parents involved in these cases from all countries need to take a close look at, to have their courts take judicial notice of this case, Zach v. Zach. This is a case that originated in 2019 in the province of Alberta in Canada. A mother and father who had two young children. They got together in 2011. They married in 2014. And in 2018 or so, the father separated from the mother. The mother deemed that the father had substance abuse issues, alcoholism, and required his visitation to be supervised, chaperoned, monitored with the children in the home. Now, granted, he had already left the home, but in the home, she would not allow him to give the kids gifts. She would not allow him to eat with the kids at the dinner table. She required the older child, who would now be about 6, to carry a whistle. And if dad was going to take her out of the home, she would have to blow said whistle so mother would hear the same. So the mother was playing judge, jury, and executioner, if you will. And father finally filed an affidavit and parenting application for a alteration and modification of his parenting time, which of course was supervised by mother. Mother had breached prior court orders. She was finally found in contempt of court this February 2021. The court basically gave her a slap on the wrist, allowed her to maintain pretty much primary residential custody. But she didn't stop. She called the RCMP, which of course is the Rocky Canadian Mounted Police, the authorities in Canada, to do welfare checks. She was on a witch hunt, and her goal was to basically eviscerate the father from the children's lives and vice versa. So the court finally had enough, found her in contempt, as you say, found her to be controlling, intrusive, obstructive, and alienating, and actually deemed her behavior as family violence. And dad was awarded sole custody. When he was awarded sole custody, the mother's mother and sister, the maternal grandmother and aunt, absconded with the girls, actually kidnapped the girls, and they were caught 33 days later by the RCMP and charged with felony abduction. And this is horrible. This can't happen, but it did. A parent has to understand that the law requires the behavior to be in the children's best interest, not their best interest. That the best parent is both parents. They have to put the needs of the children ahead of their own. They have to foster and nurture the relationship of the children with the other parent, as bitter a pill as that may be for them to swallow. That's what the law is. And so this case sends a sound message and a clear statement that if you violate the best interest of the children, if you commit emotional, mental, psychological child abuse, we're going to go beyond and punish you. You're going to be punished for your behavior. There were multiple experts on this case, and let it be known that I was neither consulted nor retained in this case as a consulting expert or testimonial expert. So I don't know the inner facts of the case. I haven't seen the pleadings. I haven't seen the court orders. I haven't seen any of the expert reports. But I did read the 13-page summation by Justice Price, who came down with this ruling, and her ruling was upheld by the appellate court. That's what makes this decision so compelling, because it was upheld by the appellate court, the appeals court in Alberta, Canada.
Mm. It's very interesting, and you referred to it earlier, but really what comes to mind is just, how does this happen? How do people get away with it? It's unbelievable, and it's happening all over the world. It's just shocking.
Yeah, and when you deem the case to be one of family violence, you're almost intimating that this case gravitated to a crime, to a criminal act.
Yes.
And so I think this case, Zach v. Zach, that's Z-A-K v. Z-A-K, and the citation is at my Facebook page on Facebook for anybody who wants to go over there and look at it. I think this case can be lobbied to legislatures as the quintessential case to escalate the commission of parental alienation to a crime, that it is a crime.
Now, there's been campaigns all over the world, in some places still, to only even get alienation recognized as a thing. There's a lot of debate around that. And then in legislation in many parts of the world, people have also tried to frame it with child abuse, with domestic abuse, and all sorts of things. So calling it a family violence is, I think, a major step in the right direction, definitely.
Yes, and you hope that the USA and the UK and your country, and of course Australia and New Zealand will follow suit.
Yes.
In egregious, compelling cases that they may encounter in their courts.
Mm. So Dean, tell me, or tell us, in your experience, where does something like this start? Obviously, couples get divorced and there's some form of revenge, resentment, something harbored there. But how does it develop to such a point where people go through to such extremes?
I think that emotions can supersede logic. Mm. Most parents, I would say 95% or more, don't know the law. They don't know the science. They don't know about a child's memory or suggestibility, and how a child can encode very quickly what you are projecting onto them. So if you are coaching them, this court found mother to be coaching, not just alienating, but coaching. Dad would also be accused of sexual abuse. I haven't seen any of the reports in that, but it is in the 13-page summation. Oh yeah, by Justice Price. So oftentimes in my cases, probably in this case, also, again, I did not see the discovery in this case, but the allegations probably escalated against dad. I see that typically in my cases where the allegations will escalate from domestic violence to physical child abuse to sexual child abuse. And it just doesn't stop. It's basically a locomotive out of control. And so, in today's world, where social media is such a very commonplace thing, for parents to put stuff on, and they don't understand that anything you reduce to writing, whether it's text message, posts at Facebook or social media, email, or even message at a parenting app like AppClose or Talking Parents or Our Family Wizard, can be used against you back in court. So be very, very careful what you reduce to writing. Many states in my country don't allow a parent to unilaterally tape the other parent without that parent's permission, because if you do, you're committing a crime. So unless you're in a one-party state, don't do that. Don't be taping your kid or another parent, opposing parent, without that person's permission. So again, most people don't know the law. They're naive. They don't know the science. They're naive. They don't understand that there are studies out there that the best parent is both parents. Kids do best by being raised by both healthy parents in a healthy family. So you can't just take the law in your own hands, and of course, a great case on that is my most recent case of John Mass, where he was shot and killed in Lewiston, Idaho, about 5 months ago. That was a case I was hired onto. And so, this is how bad it can get. This is how extreme these cases can get. And I hope this case sends a clear message to all judges that we got to take a closer look at these cases before they escalate to such, extreme measures as kidnapping a kid, as in Zach v. Zach, or Dean Tong's case of Brashear Mass versus John Mass, where John Mass was shot and killed, and now the kids will never see their father again. So these are very, very volatile cases that, for all intents and purposes, because justice delayed becomes justice denied, are ticking time bombs. Certainly COVID backed up things about a year or more in the courts. That's not an excuse, but it's a fact. And certainly judges have to deal with that. Parents have to deal with that. But you can't use COVID as an excuse to keep the kids away from the opposing parent. You can't use false allegations to keep the kids away from an opposing parent. You can't use, emotional, mental, or psychological abuse, whether it's denigration, vilification, berating the other parent in front of the kids as an excuse to keep the kids away from the other parent. So, you have to work within the constraints of the law as well as the science. My job, of course, is to help attorneys intersect those facts of the case with the science and the law and execute the same in court. Obviously, Mr. Zach had competent counsel to be able to move this through the courts in Alberta for 2 years, because the litigation basically started about 2 years ago in June of 2019, to where he finally won this case this year.
Talking about that, I wonder what the cost of such a drawn out, lengthy case would end up being.
Yeah, and I'll just give a ballpark on that, Sinta, because I've had cases that have gone up to 7 figures in my practice, where I was an expert for a gastroenterologist, medical doctor, physician over a decade ago. And his ex, the mother, was a board certified psychiatrist. Of course, my admonition during that entire case was the psychiatrist needs to see a psychiatrist.
Yes.
After she falsely accused my client about 5 times of incest. But that case wound up to be over $1 million. I would say a typical high conflict parental alienation custody case, where you may have to retain an expert, where you may have to retain a parenting coordinator appointed by the court, may run you $50,000 to $100,000. So you better know that going in. If you're going to make this a battle, and then that battle is going to become a war, that battle and then war, the costs of the same are going to go up proportionally.
I want to just take a step back. I'm going to jump around with questions a bit, but the recent case that you referred to of your client that was murdered, just as a matter of interest, what happens to that case after that? Does anything come of it, or what happens?
The authorities, Sinta, the authorities have not contacted me. I have not been contacted by the district attorney's office, who's prosecuting James Brashear, the maternal grandfather, for killing my client. I've not been contacted by the homicide detectives involved in that case. To my knowledge, the kids are still with the mother, who obviously knew or should have known that her own father was going to shoot and kill, her ex-husband. Yes. The children's father. So, I have been contacted by my client's immediate family, because they desire to be awarded custody of the kids. There's a boy and a girl in that case. And certainly the children obviously don't have a father growing up. And so I don't know if the mother's with a new man. They have a stepfather in their life, the kids. To my knowledge, the maternal grandmother is still around. I'm sure she's still in the picture. And she was a mental health expert. So she might have been a source of pathology, starting delusions and false beliefs that my client was a monster. You go back to the maternal grandfather's deposition of what he said a year and a half ago, last January, because I was the one that formatted questions for his deposition for one of John's attorneys. He said, Mr. Bashir said, and I quote, "If the court doesn't find John Mass molested the kids, they're idiots." Those are his words, quote, end quote. So you could tell that this guy was a ticking time bomb. I mean, I didn't know that he had guns, loaded guns in the house. I mean, who would know that unless you got a warrant?
Yes.
Or the police knew, and so, February 5th of 2021, when John finally had his first visitation with his kids in about 3 years, he shows up. Instead of meeting the kids, he meets a 9mm Glock, locked and loaded and triggered by the maternal grandfather, shot multiple times. So, and look, I don't like to blame and point blame at people, because I'm just a piece of the puzzle. My job is to do my own internal investigation. My job is to try to find that needle in a haystack, to find the truth behind the scenes in these cases. Obviously, in the case of alleged child sex abuse, it's pretty much a secret, right? If it happens, it's a secret. Between the perpetrator and the victim. You're not going to have any hard medical evidence. That's another reason I have my client psychosexually tested, which he did very well. There was no indication there he would hurt a fly, let alone a kid,
yes,
or molest a kid. So when you have a person who suffers from a fixed and rigid belief system that they're a monster or they're a bad person, it's hard to alter and modify that belief system. And we saw that in my case with the mother of John's children. I'm sure that was going on in this Zach v. Zach case in Alberta, Canada.
Interesting. With this case of yours, I think, as tragic as it is, I'm hoping that in the long run, it will also help highlight the impact of alienation on the family and the extended family, because people often tend to think it's just the parent that's being alienated, but this is a prime example, now that the parent is no longer there, that actually the whole family is affected by it. When a child is alienated, they don't see their cousins and their aunts and uncles and the grandparents and all of those. So it would be interesting to learn if anything comes from this beyond this point.
Yeah, it's an excellent point you make, and usually the courts don't document in their rulings that the emotional, mental, psychological abuse has trickled or metastasized, if you will, onto the extended family members. And that's a very important point, because it does. Look, I think judges need to take a hard line on these cases. I don't think there can be slaps on the wrist. I don't think judges should be erring on the side of caution. Okay, oftentimes they do so in these cases because they don't really know the truth, right? So I'm an expert. I can give an opinion to a reasonable degree of psychological scientific certainty, as can Dr. Jennifer Harmon, as can Dr. Amy Baker and Dr. William Bernay and all the experts in this field. But with that said, judges have the authority and the right to defer to that expert or depart from that expert. That's their discretion. Yes. So with family court judges, the operative word is discretion, and they have the discretion to side with the court-appointed guardian ad litem or parenting coordinator. They have the discretion to depart from that person and go with the father's expert or the mother's expert, or they can go beyond, as Justice Price did in this case of Zach v. Zach, and find that the mother's behavior was consistent with family violence, even though she didn't actually have a weapon to perpetrate violence with. Okay, so what you're looking at is psychological testing. I believe that was done. I know she required a risk assessment of the father. I don't know if mother was ever psych-evaled. I think she was, but of course I don't have the report. And so you want to look at her validity and clinical scales on the MMPI. You want to look at her Milan results to see if she has any traits or features that would be consistent with a personality disorder, like histrionic or or narcissistic borderline personality disorder. But I don't know. I'm not privy to any of that stuff. So the court has to take in all this information from all these fiduciaries and all these experts and come up with a decision, because only the judge can rule on witness credibility and the ultimate issue at bar of whether abuse was perpetrated or not. This Judge Price, ruled the mother was not credible, the father was credible. That's her right. That's clearly within her province to find. The judge also ruled that mother's behavior was alienating. So she basically, as I say in my book, Elusive Innocence, committed a fatherectomy, parentectomy, where she tried to eliminate the father from the kids' lives and vice versa.
I like the term parentectomy. Yeah.
Well, yeah, and you look at my book, Elusive Innocence. It was reviewed in the American Journal of Family Therapy 15 years ago, in 2006, in an article titled "Parentectomy in the Crossfire."
Yes.
My book, Elusive Innocence. So you look at my expertise and false allegations of child sexual assault as being the most acute and egregious form of parental alienation. Or you could top that and say my client's murder, John Mass, obviously is the most egregious, really. But how many experts, how many lawyers, how many people get involved in cases where their client is shot and killed?
True.
Well, I've been on both sides of this ledger now. I've been doing this work a long time, back to the mid-90s. I had a client in 2006 who murdered his wife and shot his judge. He got 40 years in prison. So I've been on the side where my own client was the perpetrator of violence, and now I'm on the recipient side where my client, sustained violence and was killed. And so this happens on both sides, and I have seen cases, and usually since it's the cases where the judges are fumbling, they are just fumbling their thumbs on their lips, not knowing what to do. The lawyers don't have a real good grasp of the litigation because they don't get this stuff in law school, and it's the cases that drag through the system for months, for years, that wind up with these harsh results where somebody's hurt, the kids are hurt, the kids are kidnapped, and the case becomes the Titanic hitting the iceberg.
I think there's a fear that comes from that. It also came up for me now when people really go to those extremes and to commit murder. And I know you've mentioned a number of tests and things that can be done to determine disorders in personality and all that stuff. But is there a way of knowing? I suppose not, of knowing beforehand that somebody is capable of going that far. If it's your client, do you have any inclination?
Well, you'd have to get psych eval results, Sinta, and they're only good for like 3 to 6 months. But we're looking at the validity scales on the MMPI-2. So you're looking at a high K scale where somebody's defensive, a high L scale where somebody's lying, a low F scale where you're trying to hide your psychopathology. And then you go over to the clinical scales and you look at a high score on what's called the PD scale, which is the psychopathic deviant scale. If you have criminal psychopathy or sociopathy, where you could hurt somebody, where you could grab a gun or a knife and hurt somebody, and show no remorse because you're a sociopath. So unless you have those data, unless you are looking at the empirical raw test data and scores of those psychometric tests, you couldn't possibly be prescient and look into a crystal ball and say, "Gee, this person's going to clearly blow. He's going to blow a head gasket in about 6 months. He's going to have a psychotic break from reality. He's going to decompensate, and he's going to kill that person."
Yes.
Well, we had no psych eval on John Mass' mother. John Mass' ex-wife, the mother of his kids. We had no psych eval results on the maternal grandparents. We had nothing on them.
Mm.
All I had on John was my results that I put him through my own clinical forensic psychologist for psychosexual testing. So John actually proved a negative and proved his innocence, that he didn't have the capability of molesting any kid, let alone his own kids. And we had this in data scores, and finally John was cleared by the North Dakota court, December of last year, 2020, a little over 6 months ago. It was a few months after that he was supposed to get his first visitation. It never came to fruition because he was shot and killed.
Yeah. Getting back to the Zach versus Zach case, don't have the back history. Do you have any idea what was the initial agreement in their divorce? Because what I'm trying to get at is, how did the mother manage to get into a position where she supervised the father's initial visitations and only allowed it in her home?
Yeah, I think the father just went along with that,
Okay.
for the purpose of probably saving, costing him money. So I think he was trying to save resources and prevent protracted high conflict litigation. I also think he was trying to appease the mother, hoping that her behavior would change and she would relent, where he could get back in the ball game there and see these kids unsupervised and overnights, at least what I call Disneyland dad visitation rights. Well, he never got there. She was requiring him to have supervised visitation in her home. And then, of course, the kid had a whistle, where if he would go around the house thinking that he was going to abscond with the kid out of the house, she had to blow the whistle. There's where the coaching came in.
Yes. It's
So,
unbelievable.
and so this is what happens in cases. And I go back to my own case in the mid 80s, 35 years ago. And I said to my then wife, 3 words: court is court, which means when you go to court, you let a judge handle it, and you do not communicate with the opposing party except through the parenting app or text message or email, however the court has mandated you to do so.
So in the event of such a situation where you find yourself as one parent being controlled by the other parent like that, let's say right in the beginning, when you realize something's wrong, what's the best thing to do? What immediate action can you take to prevent it from going so far and being dragged out so long and possibly blowing up in some kind of tragedy?
Yeah, so in today's world, I require all my clients or even prospective clients to wear a body cam. I mean, it's pretty much a necessity. You got to have some accountability. You got to have that video, audio accountability.
Is that legal though?
Well, I mean, it may be legal, it may not be. Oftentimes, a lawyer can use it for impeachment purposes, if nothing else, in a court of law. So you got to have that body cam, and you can get them on Amazon for $35. Spyware today is unbelievable what they have out there. You got to come back to your computer and do a timeline, a journal or chronology by dates and events. Jog your subjective memory, going back and start this timeline. Your lawyer's going to need that. I'm going to require that if I'm on board. And a judge has to have a good grasp of the timeline of the case. Where the case was, where it is, and if you're a victim of parental alienation, how do you need to fix it to get back to at least some type of meaningful visitation and attachment in the kids' lives. So when you see a case like Zach v. Zach, and you see a mother who is deliberately requiring her kids to attach to her, to enmesh to her, where the kids become like 100% enmeshment, and they become clingy, and all of a sudden they want no part of dad. Well, that's probably a belief system that's projected onto them, and now you could have a case of what's called F24 in the ICD-10. Shared delusional disorder or shared psychotic disorder, where the mother has possibly projected or transferred her false beliefs, her fixed and rigid beliefs onto the kids. That's, in my opinion, what happened in the John Mass case. But again, we had no psych eval on mother. This is where the courts need good information to be able to move forward. and to be able to get what's going on behind the scenes psychologically, what's going on in the brain of that person.
It makes sense because often this alienating behavior is very, very subtle. So, instead of relating it yourself, if you could have proof, like having filmed it or recorded it, it's obviously better to you.
And actually, what's better evidence than a body cam or a timeline is, of course, a witness, and certainly an objective witness, a witness who has no axe to grind, who has no fight in this case, who can be objective and neutral, independent, impartial. That would be a doctor, a nurse, a teacher, somebody who's a mandated reporter, who has to report a reasonable suspicion of child abuse. So if you have a friend who's a mandated reporter, social worker, therapist, teacher, cop, priest, great witness for your case.
Okay. Something else that I've come across also in my work is in the event of alienation that happens post-divorce, there's often some traces or indications of similar behavior in the marriage. I have found that. Have you found anything of the sort?
Oh, sure. I mean, but in my cases, because they're usually much more intense than just parental alienation with false allegations or unfounded allegations of abuse. And I get cases where you see 5, 10, 15, 30 allegations of abuse,
Goodness.
Oh, yeah. Just, incredible. So.
And they're all false accusations.
Well, by false, you're meaning bad faith, premeditated, malice aforethought. I'm gonna pick up a phone and call 1-800-96-ABUSE, which is our toll-free hotline in Florida, and ruin your life. You're not gonna have that evidence. So that's why most people are not prosecuted for false allegations. The police will tell you it sends a chilling message to future women and children who would disclose abuse. They don't like to prosecute those cases, arrest for probable cause. They usually don't. So most cases are unsubstantiated or unfounded. They don't preponderate. They don't meet a preponderance of evidence, 51%. And that's what a judge is looking for. If you can get a case where you can prove mother spearheaded or orchestrated or dad did a witch hunt, fantastic. Then you can try to prosecute for false allegations. In my state of Florida, that's a felony. In most states, it's a slap on the wrist. Okay, so it's almost like the law is entitling and encouraging this type of behavior because they don't sanction it. Yes. There's no real sanctions for it. So when you don't sanction something, when you don't send a message that you're going to be punished for this behavior, it's almost like, okay, we'll allow you to keep doing it.
We'll just see how far we get with it, sort of thing. Yeah, push it to the limit.
So we hope that this case from Canada, not to use the word like metastasizes, because that of course involves cancer, but that this decision does spread to other countries that are affected by this, which is pretty much all over this planet.
Yes, I sincerely hope so. It's much needed and wonderful that this happened. Just in closing, Dean, what does it mean for alienated parents, apart from the huge work that needs to be done all over the world about getting legislation to change? Like you mentioned earlier, false allegations is basically a slap on the wrist, if that, in most parts of the world. Those parents that are alienated, that have been alienated for 10 years, 20 years.
Well, I think this decision, Zach v. Zach Center, needs to be lobbied by professors of psychology like Dr. Harmon, Dr. William Bernay, who of course is a psychiatrist. He's published academic textbooks on this. He has lobbied to the DSM-5 committee. He's responsible for, in large part, getting the ICD-11 to at least acknowledge caregiver child relational disorder, which is going to be published as a coded QE 52.0 in January of next year. I give a lot of kudos to Dr. Bernay on that. I think this decision now needs to be printed out and memorized and lobbied by these professionals to legislative committees, to judges in cases, obviously to attorneys who are litigating and trying these cases.
So we need to spread the news. And then just in your experience, a person who's falsely accused to that extent, I mean, you're talking about 15 false accusations. What is the impact of that on a person? I mean, if I think about it, the immediate effect of it on your job and your security and all of that.
Yeah, and as a guy who's been through it on the recipient side myself some 35 years ago, I can tell you it's total physical, psychological, emotional, spiritual, and financial devastation. And I can tell you it can take you to your knees in a New York minute. So imagine what it does to the children. Yes. And the harmful effects, the deleterious effects on the kids. We start seeing psychosomatic disorders with the children, headaches and stomach aches and nausea and vomiting, and then depression and anxiety. And when the kid gets older, self-mutilation and suicidal ideations and the trauma. And now they have a label for this. There's a adverse childhood experiences, ACEs.
Yes.
And ACEs certainly is something that needs to become more commonplace in these cases, with therapists, administering the ACE test for parents to take the ACE test. And if you get a clinical score of 4 or higher, that's supposed to be clinically significant. And predict in the future that, hey, this kid's going to be a real problem. He's going to be a problem in school. He might hurt other kids. He won't be able to have good peer relationships going forward. This kid is a kid destined for prison. So, I think we need to do more of this. And certainly this Zach case, I didn't see where the parents of the children were administered what's called the TSCYC. That's the Trauma Symptom Checklist for Young Children test, the John Briere test. I try to inject as much forensics in a case as I can, Sinta, because most of these cases are hearsay. He said, she said, what a child said.
Yes.
You don't have a DNA or bodily fluids or broken bones, medical findings and opinions. You don't usually have that. And so you have to try to inject experts, and testing is very important for a judge as the trier and finder of fact to make a decision that is truly in the best interest of the children and the family And I'm
just thinking the impact on children of having all those evaluations and tests and things also is profound if they had to go through those things, especially with sexual accusations.
Yeah, and I mean, there are studies on repetitive investigations and interviews of children. How children can become, their memories can become tainted and contaminated and adulterated with these multiple interviews.
Yes.
And their first initial interview is their most reliable because kids don't have good memory. They don't have good memories, and they decay over the passage of time. So it's important to do this right and do it right the first time, because a lot of these cases, a lot of my cases will accentuate. It will escalate, and the courts allow that escalation. That's another problem. You can't be allowing that escalation. You got to try to nip this in the bud within the first 6 months or so. And unfortunately, I see cases, my cases anyway, can last 3, 4, 5 years in litigation.
Yes, and then a lot of harm is done on so many other levels. It's unbelievable. Yeah. Well,
and then you look at psychological testing. Those results are only good unless it's a sexual test, like the Able assessment for sexual interest, the Able screen test. Most general psych tests are only good. The data is only good for 3 to 6 months. So that data is going to become stale, and judges don't know that because they're judges.
Yes.
They're lawyers that have been either appointed or elected as a judge. Most judges have a meek and mild background in psychology and science. So, the lawyers have to step up to the plate here and get this stuff before the court. get these cases before the court and get these cases to a final resolution, a final court order sooner than later.
Yes, I agree. There's a huge educational task that's constant and that still needs to be done. But let's celebrate this case, this Zach versus Zach case, sorry, as a major landmark, and it gives hope to many out there who's in similar situations. And I think we need to all get to work and spread this as fast and rigorously as we possibly can.
Correct. So and not just aggrieved fathers, Sinta, but mothers too. Mothers are also recipients of victims of alienation. And I get a lot of clients. I get a lot of mothers calling me and emailing me and messaging me on Facebook that they have gone through this, that they are the victim, not the dad. And so this is not a gender biased issue here. This is not a gender biased type of abuse. This can affect any gender at any time.
Definitely. Definitely. Yes. Well, thank you so much for having this conversation and giving us some more information. I really appreciate it. And I want to honor the work that you do, Dean. It can't be easy. Keep it up, and hope to chat to you again soon.
Thank you again for having me, Sinta.
Thank you so much. Take care.